I understand that you handle cases and claims against business owners who sexually harass their employees. What makes your law firm unique from the hundreds of Texas lawyers who handle sexual harassment?
Well, one of the things that makes us unique, I think, is my background and training. There's very few, if any, lawyers out there practicing who have the background and training that I have as a former police officer, former criminal investigator, and former assistant district attorney of Travis County, as well as being a chief of police. So I have the tools and the background and the training to conduct extensive criminal investigations. And these cases, sexual harassment, border on the line of being semi-criminal type of cases. These are definitely different cases than car crash cases that most personal injury attorneys handle and that most employment attorneys handle. Many of them don't know how to do a criminal investigation, I have to say. Secondly, what differentiates my firm is I sue the business owners and the persons who commit the acts of the predatory acts of sexual harassment. So I don't sue co-employees, I don't sue low-level managers. If that kind of sexual harassment is going on, I will probably guide you and refer you to a 1964 Civil Rights Act, EEOC, Equal Employment Opportunity Commission lawyer who can assist you with a claim against the company. The cases I handle, many of them are small businesses, law firms, real estate offices, business entities, banks, small firms like that, small businesses which there's sexual harassment occurring, and it's not large businesses usually. And it's businesses, quite frankly, where the owner is the one who's the perpetrator who's committing these acts against the employee. So that's what distinguishes me from the other firms that sue the companies. I sue the individual who commits these acts.
What is sexual harassment?
Well, that's very broad. Actually, sexual harassment can be words or conduct. So I break it down into three categories. One is lewd comments that are made by an employer to an employee, repeated, constant barrage of lewd comments every time the employee comes in. The second would be lewd acts by the actual employer, by the predator, the one who's committing the sexual harassment, to the employee. Acts such as partially disrobing, exposing themselves to employees would be an example of that kind of lewd act. And third would be actually physical contact with the employee. I'm talking about fondling, groping, or molesting the employee by the employer. And that, in Texas, constitutes an assault which is actionable in tort law.
So what you're saying is that sexual harassment may consist of three different categories: lewd comments of employer, lewd acts of employers, or unwelcome touching or groping by employers. Is that correct?
Exactly.
I have heard that under federal law, an employee can't sue his or her employer for sexual harassment unless the company employs at least 15 full-time employees. Is this correct?
Yes, that is correct, and that's a great point to make. What distinguishes my law firm from the scores of employment attorneys that are scattered throughout the state of Texas. The employment attorneys are looking at cases where there's 15 or more employees because federal law, the 1964 Civil Rights Act, which governs the Equal Employment Opportunity Commission, that forbids sexual harassment and also racial harassment or racial type of discrimination. What differentiates my firm from those firms is we don't depend on the federal law. We do not file and pursue these causes of action against employers based on federal law. We use Texas state law. Therefore, we don't have any concerns about how many employees your employer hires. We're not suing the company, we're suing the predator. And I think that's a real advantage for people too, because if you get into lawsuits against your employer, it can be used against you later if you're going to be hired by another company. Nobody wants to hire somebody who sued their last employer. Okay, let's be honest about it. So we are taking our causes of action directly against the predator, and it does not matter whether or not there's 15 or more employees under federal law because we are asserting a cause of action under state law.
How expensive is it to hire an attorney to handle a sexual harassment case?
Well, it varies with a lot of the employment attorneys. They charge an hourly fee. Some of them charge a flat fee. Some of them even charge a retainer to get started on the case. At my firm, we handle these exactly the same way as car crash cases, which means You don't pay me any money until I get you a recovery, and unless I get you a recovery. Then it's a contingency percentage fee. I receive a percentage of the gross amount that's paid in a settlement, or if there's a judgment in court. If I'm unable to get a recovery for you, you don't owe me a penny, not even for any of my costs out of pocket. Zero risk to the person who hires me.
What advice do you have for women or men who are the victims of sexual harassment?
The first advice I have is don't do anything unless and until you contact a skilled attorney like myself who has experience in handling these kind of cases. I see people who write letters, they go to human resource meetings, they file charges with the police, or they file a complaint against administrative agencies against the person doing this. My advice is don't do a thing until you've actually spoken to a skilled, experienced attorney like myself, because you can damage your case severely if you don't. My law firm's unique in that, again, I have the criminal investigative background and experience to look into these cases, and we have tools, procedures, and actual equipment that we utilize. If a person's been sexually harassed and they can hang in there for a couple more days, we can do some things to make sure we capture some of the evidence, which is critical when a case is going to go to trial or will help get that case settled. And believe me, if we get certain evidence, that's the ones that are able to get cases settled quickly, because the last thing the predator, the owner of the business, or high-level management wants is to have their lewd acts portrayed in court by electronic evidence. So the first thing we want to do is try and capture some of that evidence to use to help our clients in their claims.
Do potential clients have to come into your office to get a consultation?
No, they don't. We handle a lot of phone call consultations, and I get a lot of email questions and inquiries throughout the state of Texas from folks. And I always want to let them know that our conversations and communications, whether by email or by telephone, are completely confidential. But there's no need, and a lot of people don't even come in to the office to actually hire me. We send out contracts by email, and people execute those, send them back, and we're on the case within 24 hours.
What do you charge for a consultation?
We charge nothing. There's never a fee for a private consultation, so I encourage people to call us in 512-708-1650 or go to my website, kevinmadison.com, and you can email me and talk about your case with complete confidentiality, and we'd be happy to represent you.
In what locations and cities do you handle these cases?
Everywhere in Texas. We travel up to Dallas, Fort Worth. We've had dozens of cases up there. Houston, Brenham, Lubbock, Austin, San Antonio. Throughout the entire state of Texas, we handle cases. Again, please give us a call. Let's talk about your case. My creed is to take care of you as if you remember my own family. And I have an AV rating, which is the highest rating awarded by the Martindale-Hubbell Legal Directory, which is the only recognized legal directory that's been in existence for 160 years. It's the highest rating awarded by Martindale-Hubbell for legal competence and ethics. And I would encourage you to give me a call and let's see if we can work on your case together. I'd be honored to represent you.